strike me as necessary or appropriate here. And of course, we don't know yet if there are going to be other witnesses. At least, I don't know whether the other two subpoenaed witnesses are or are not going to be testifying.
Right, I just want to make my objection for the record. I don't know if we're on the record.
Okay, thank you.
And Your Honor, just personal conflict, I've got an aggravated murder jury out. They've had a couple questions. We may have a verdict. If there is, I'm going to ask your indulgence. Let me be excused. My colleague and co-counsel, Mr. Martin, will be here. I'm not planning on leaving, but if they call me, I'm going to have to go.
Okay, absolutely. Someone told me that you had a jury question.
It's in Judge Sheehan's room. Your Honor.
Okay, good.
Thank you.
Thank you, Your Honor.
All right. Thank you. Bye.
You know, by the way of minutia, of which I'm very fond, I looked at the docket, the public docket, yesterday, and for the first time noticed that for the last 4 weeks or so, my entries kept referring to this matter of a motion for mistrial on jeopardy grounds as a motion for mistrial. Thank you for bringing that to the court's attention. It never hit me till yesterday that wasn't wrong. So we today did an entry saying every time we said motion for mistrial, we really meant motion to dismiss. And then we issued an email this morning to Mr. Mitchell and Mr. Brennan, who represent the other two subpoenaed witnesses, alerting them to the fact that by inadvertence, they failed to file their motion to quash on all 3 dockets. They just filed it on one, and maybe not appreciating that they had to file it in all 3 dockets. So presumably they'll take care of that. Then the other thing on the public docket that concerned me was there were 2 different briefs in opposition filed with the state that were not imaged. Now, you folks probably don't operate on the public docket, right?
Oh, okay. I think I can answer that, Judge. When an item is labeled as a brief, it is typically not imaged for public viewing. I don't know why that is the case.
Well, that would be under the court's setup.
Sure.
General pleading, that's another thing that isn't imaged for some reason.
Right. So, and from our perspective, we can't call it a motion because we're not asking. It is a brief.
Like it, and I
No,
wouldn't like it if you did.
we wouldn't want to do anything like that. So we call it a brief because that's what it is. And pursuant to court's rules, it ends up not getting imaged. So we can provide the court with anything it needs that we have filed in this case.
Well, I get it when I come to work. I get it, and so I read it this morning.
All right.
All those briefs I read this morning, but I just wondered if there was something going on. My stat attorney thought it was something related to that, but that doesn't happen on the civil docket, so I didn't understand. A brief on the civil docket gets imaged, so.
He said we'll be ready in 1 minute.
Is that okay?
If I could, are the Zoom people in? She said that, I just texting with,
Who are the Zoom people, by the way?
so,
They're not broadcasting,
oh, all right, good to know.
but I
Okay.
can start that.
Whenever the court wants.
Excuse me, who are the Zoom people, just so I know?
If I could answer that.
Okay.
Everyone with the last name Pointer is a relative of the deceased victim in this case, Alishah
Okay.
Pointer.
Okay.
And that's everyone except for Jenny P.A. That is Jeanette from our office, a victim advocate,
Okay.
working with the family. So it's all of, everyone there is family or a victim advocate.
Including Cheryl?
Cheryl, you can't see Pointer.
Okay.
Yeah.
So you're accommodating your victims' representatives here?
This Zoom setup satisfies Marcy's law.
Yeah, thank you.
Yes.
Appreciate that.
this will be okay, Judge. The way it's set up is fine.
Okay, we're going to go on the record at this time. This is the State of Ohio versus Brittany Smith, the State of Ohio versus Anthony Bryant, and the State of Ohio versus Hakeem-Shomo. This is criminal case number 670878. We're on the record. The State of Ohio is represented by 3 prosecutors. Mr. Filiatro, Mr. I'm blanking, Evan.
McNair, Judge.
I'm sorry, couldn't come up with the rest of it. Mr. Bryant, and,
Special Agent Kristen McCaskill with the FBI, Your
I'm
Honor.
sorry,
Special Agent Kristen McCaskill with the FBI, Your Honor.
thank you very much. So Ms. Smith is here with Mr. Martin and Mr. Slackett. Mr. Bryant is here with Mr. Fallon and Mr. McGann, and Mr. Shomo is here with Mr. McDonald and Mr. Kyler. So,
Your Honor, I'm here on behalf of Sean Kilbane. I'm Brendan Healy.
okay, thank you. I did not know Mr. Kilbane was represented by counsel, so would you state your name again, please, sir?
It's Brendan Healy.
So, it was my understanding that no one has filed a motion to quash the subpoena against Mr. Kilbane. Is that accurate?
That's correct.
Okay, so that's why when I came out here today, I said that it was the court's plan to entertain testimony from Mr. Kilbane if defense counsel had it, and then we proceed to what I'll loosely call oral argument to go over some questions that the court has. Is that agreeable with everyone?
Yes, Your Honor.
So, did you wish to call Mr. Kilbane to the witness stand? And well, let me just say for the record, this is a hearing on the motions, 3 of them filed by the individual 3 defendants to dismiss this case on double jeopardy grounds. Mr. Bryant had a motion filed in his behalf. A separate motion was filed on behalf of Ms. Smith, and then Mr. Shomo's counsel sought permission, was given permission to simply have the motions of the other parties be his motion, since they found them complete and sufficient. So, you want to proceed then with the examination of Mr. Kilbane?
Yes, Your Honor.
And you're doing that?
I will. Your Honor, what I'd ask to put on the record, which we discussed a minute ago, is it's a criminal case. We're asking for separation of witnesses, which would include personal representatives, meaning attorneys for the other parties that are subpoenaed here. So I would ask that they be excused from the live testimony.
Okay, so your reference is to Mr. Mitchell and Mr. Brennan being present, since they represent the other 2 individuals who were subpoenaed in this case. And as the court shared with you before we went on the record, I did not wish to grant that motion for separation.
Thank you.
Okay. So are you calling Mr. Kilbane to stand?
I will, Your Honor.
Okay, Mr. Kilbane, step forward to be sworn. Do you solemnly swear the testimony you're going to give today will be the truth, the whole truth, and nothing but the truth as you may answer to God?
I do.
Very well. Go ahead, please.
Thank you, Your Honor. Mr. Kilbane, would you identify yourself for the court reporter and give your first and last name, please?
Yes, my name is Sean Kilbane. Sean is S-E-A-N, Kilbane, K-I-L-B-A-N-E.
And you're the Assistant Cuyahoga County Prosecutor?
Yes,
And you've been one of the 3 prosecutors assigned to prosecute the case involving Mr. Bryant and Mr. Shomo?
yes,
Okay. And did you attend the trial of this matter back in March?
yes,
Okay. And directing your attention back to the beginning of the trial in March, did you have occasion to have conversations with Judge John Russo's bailiff?
yes,
Okay. Did those conversations take place outside the presence of the defense attorneys?
Yes.
Okay, and when did they occur?
There was one conversation that occurred, not even a conversation, it was a communication that occurred outside of the presence of the defense attorneys Thursday afternoon in the first week of trial.
Okay, and the trial only lasted a week, so Friday would have been the last day, correct?
Correct.
Okay, so on this Thursday, do you recall what time it happened? Was it at the end of the day or on a break?
It was in the afternoon, it was sometime after lunch, and it was during a break.
Okay, and who was present for this conversation?
It was myself and Kathleen Dunham.
Okay. None of the other prosecutors were present?
No,
None of the defense attorneys were present?
no.
What was the nature of the conversation?
Kathleen had asked me to step outside into the hallway. At the time, I was sitting at the trial table with, it was just me and Special Agent Kristen McCaskill. I don't know where Kevin Filiatro was or Ben McNair. She asked me to step outside because she needed to ask me something.
Okay. And what was it that she asked you?
She asked me if the state was planning on calling any witnesses to establish independent proof of the conspiracy prior to any of the co-conspirators testifying.
Okay. And would it be fair to say that that mimics the nature of the text message that was sent to the prosecutors on Friday evening, 6:11 p.m.?
What do you mean by mimics?
It's the same issue.
They're different, but this communication was more general than the communication she had over the text message.
Okay. And did you say anything to Ms. Dunham at that point?
I did. I told her half facetiously, half truthfully, that, to be honest, we didn't know who we were calling the next day.
Okay.
And that was my response.
Okay, and that was the whole extent of the conversation?
She did indicate to me that Judge Russo told her that it was okay for her to be asking me that question.
Okay, and how did that come about, that last phrase that you just mentioned, that last sentence?
I don't know.
I mean, did she lead off with that, or did she add that at the end, or?
I don't recall when exactly she said that in the conversation, but it happened at some point while she was talking to me.
Okay, so that would indicate to you that Judge Russo authorized that conversation, correct?
All I can tell you is what she told me.
All right. And what did you do after being asked that question by Ms. Dunham?
I went and I went back into the courtroom, and I sat down next to Kristen McCaskill, and then soon thereafter, Kevin Filiatro and Ben McNair came back to the trial table.
Okay. And did you disclose to them what had taken place?
I did.
Okay. As a result of that conversation, did you have any concerns about the nature of the conversation with you?
Did I have concerns before or after I talked to Kevin?
After the conversation with Ms. Dunham, did you have concerns about having had that conversation with Ms. Dunham in this case?
I did.
Why did you have concerns?
I thought that communication should have been put on the record in front of all the defense attorneys in open court.
So would that be an indication you consider it to be an ex parte communication?
It was me and Kathleen Dunham, no other parties were present, so yes, I would consider it ex parte communication.
Okay. And did you consider it to be something more than procedural in nature?
Objection.
You objected.
I did. Objection. Right.
Thank you.
I didn't make that determination at the time.
Would would it be fair to say that asking, meaning Ms. Dunham asking you if you're going to call any more witnesses before you get into the co-conspirator statement, that was something more than scheduling, wasn't it?
Again, I didn't make that determination at the time, but just based on the nature of the conversation, I did think it was appropriate that that communication be had in open court in front of all parties. But I didn't make a specific determination on whether it was something more than procedural.
Now that you've had time to reflect on it, because this happened 2 weeks, 3 weeks ago, hopefully. Have you had time to reflect on that nature of the conversation since then?
I've thought about the communication, yes.
All right, and is it still your opinion, or is it your opinion now that that was something more than procedural?
I'll say I still hold the belief that that communication should have been had in open court in front of all parties.
And directing your attention again to that same week of trial in this matter, did you have any further communications with Ms. Dunham relating to this issue?
I did.
When did that take place?
Friday morning, which would be the next day, before any testimony started.
Okay, so probably like 8:30 in the morning, 8:30 in the morning?
I think it would have been before 8 a.m. We started each day of testimony at 8 a.m., so it would have been before 8 a.m.
Okay. And what was the nature of that conversation?
I was sitting at the trial table again. I know Kristen McCaskill was there. I don't recall who else was sitting at the trial table, if anyone was sitting at the trial table. And Kathleen came up to the trial table and asked me if there was any follow-up from our conversation yesterday.
Follow-up meaning, what did you take that to mean?
Follow-up from our previous conversation, or follow-up from the communication that happened Thursday afternoon between when Kathleen took me out of hallway.
Okay, meaning that she wanted to know, or the judge wanted to know through her, whether you were going to call any more witnesses before you got into the co-conspirator statement.
I don't know. I can't tell you what the judge was thinking. I can just tell you Kathleen came up to the trial table and said, is there any follow-up from our conversation yesterday?
Okay. And did you have a problem with that conversation when it happened?
I did.
Okay. Did you feel that should have been addressed in open court with all the parties present?
I did.
Did you alert the defense attorneys at that point that this was going on?
At that specific point,
Yeah.
I did not.
Did you alert your other two co-counsel, other two prosecutors at that time?
I certainly alerted Kevin Filiatro of that communication. I don't recall if I alerted Ben McNair to that communication.
Okay. And directing your attention, let me ask you this question. Did you have any further communications with Ms. Dunham the remainder of Friday up until the text message was sent Friday evening?
I did not.
Okay, so Friday evening, were you one of the recipients of a text message from Ms. Dunham?
I was.
I think I have this, as an exhibit to the 2 pages?
Section 3.
Then I have 2 pages. You see the 2 pages? Oh, you know, I think your 2 pages have been collapsed into 1 page.
Okay.
I have the same.
All right.
That's your defense exhibit A.
Approach your witness, Judge.
Yes, please.
Mr. Cobain, Hayes, been marked as defense exhibit A. Could you take a look at that and identify it if you can?
Are you promulgating this on behalf of all defendants or just your client?
On behalf of all, we're all joining.
Okay, so this is plural defense exhibit A, right?
Right.
I recognize it.
Direct your attention to the, looks like a screenshot of a text message. Was that text message sent to you?
On page 2?
Yeah.
Yes, I was on this text thread.
Who else was on that text message?
Kathleen Dunham, Ben McNair, and Kevin Filiatro.
No defense attorneys.
Correct.
Okay. And what time was that text message sent?
Which text message are we talking about? Are we talking about?
Which begins today. What's this, today?
Yes, that text message was sent at 6:10 p.m.
Okay. And that would have been on Friday?
Correct.
Okay. So that was following the 2 conversations or encounters that you had with Ms. Dunham on Thursday and Friday, correct?
That's correct.
6:10 p.m. was after court hours, correct?
Correct.
Okay. We had adjourned that day, I don't know what time, but 6:10 was certainly after the court had adjourned.
Correct.
And what was the nature of the text message?
Do you want me to read it?
Yes.
Well, surprise, surprise, I read English, and this is an exhibit, and we know what it says. And furthermore, this is not a matter that I believe to be in substantial dispute, either as to the sending of it or its contents. So can I ask that you move on to your next question?
Okay. Were you part of the text message from Ms. Dunham that she said she was sending on behalf of the court?
Well, it says what it says. So let's move on.
All right, Judge, the prior hearing was on a different motion. You want us to use the same exhibit from that motion and accept that testimony? This is a double jeopardy motion. We introduced this before at the mistrial motion.
I know that. I didn't mean to suggest you couldn't introduce this exhibit in this hearing. I just didn't want to take time in reading its contents. There's no dispute that this was sent, who sent it, who received it, and the time and its contents, so that we could move on.
Okay. Is it fair to say that in the body of the text message, that Ms. Dunham expressed to the prosecutors that the judge wanted to make a good record?
She says in the text he wants to make a good record.
Okay. And what did you take that to mean?
That he wants to make a good record.
Regarding what?
I don't know. He wants to make a good record.
Okay. Did you think that it had something to do with the statements of co-conspirators being admitted in a timely manner?
If you're looking at the body.
Objection.
Overruled. Go ahead, Mr. Cobain.
Can you repeat the question?
Yes, did you take that to mean, or did you, having read that text message, infer from that that there was concern about when the judge wanted to know if there's going to be more testimony concerning evidence before the co-conspirator statements were admitted?
Yes.
Okay, and that was an issue of contention in the trial, was it not?
It was an issue of contention, yes.
Yes, it was raised prior to trial, and a pretrial motion was raised during the trial, correct?
That's correct.
Okay. So having read that, why would you think the defense attorneys would be included in that?
I'm sorry?
Did you think the defense attorneys were meant to see that text message? Objection.
Sustained.
You think the defense attorneys would care if a good record was made on that issue? Objection.
That's really beyond our concern, so it's objectionable because it is irrelevant.
After having seen that text message, did you have a conversation, text, phone call, meeting with the other prosecutors on this case?
We did discuss it, yes.
How did you discuss it? What motive?
We discussed it via text message between us, myself, Kevin Filiatro, and Ben McNair.
Right? And as a result of that conversation, what happened? What did you do?
Well, we decided to disclose it to defense counsel.
Why?
Because we came to the determination that this was something that defense counsel needed to be aware of. This communication was something that the defense counsel needed to be made aware of.
Okay. You felt concerned that it was an ex-parte communication?
It was an ex-parte communication.
Okay. And you were concerned enough to make defense counsel aware?
Correct.
And what time were defense counsel notified of that text message?
Well, can I refer to the email here?
Sure.
In Defense Exhibit A? Kevin Filiatro emailed all defense attorneys on the case at 11:27 p.m. on March 10th of 2023, which would have been Friday, which would have been the same day.
Okay. So about 5 hours plus later?
Correct.
Okay. During that 5 hours, were there any other communications with members of the prosecutor's office?
Communications with myself, communicating with anyone?
Or the other two prosecutors? Was anybody else communicating with anyone else in your office, supervisors, appellate people?
Kevin Filiatro, I know, talked to John Costco, who was the supervisor of the major trial unit in the prosecutor's office, and I know John Costco told Kevin that that communication needs to be disclosed.
I'm sorry, John Costco said that?
John Costco said that, yes.
Okay. And what was the basis for disclosing it to defense counsel?
Your Honor, I'm going to object to communications within the office. I mean, it's work product and it is privileged. They shouldn't be acquiring these communications internally about how this was handled.
It's Mr. Healy, isn't it?
Yes, Your Honor.
I guess I cannot agree that it's work product. We are not talking about your selection of an expert witness. We aren't talking about your consideration of a plea bargain you're going to offer. We're talking about these issues, which I think are separate and distinct from work product, as I think and use that term. So,
Well, I guess my only counter to that, Judge, is that it was a communication internally about how they were going to address this matter in court. We still had a pending criminal case going on, and it did affect the criminal case itself. So I would consider those
certainly imagine there could be communications that I would agree were work product relative to the prosecution of that criminal case. I don't consider this. I think it's fair game for him to testify that they discussed what to do with it. He consulted his supervisor, and the supervisor gave him instruction. We could go farther, and we would be far afield, and I would agree with you. But at this point, I think we're on solid ground. This is proper.
And look, I don't want to test the court's patience on this.
You're not
but,
testing my patience.
I also object on the basis of attorney-client privilege. I would think that would
Do
actually.
you think Mr. Costco was Mr. Kilbane's attorney when he said disclose it?
Well, the state of Ohio is the party. These attorneys represent the state of Ohio. I don't think John Costco is the client of the state of Ohio as a client. We make communications internally amongst attorneys that represent the state of Ohio.
I'll have to think about that one long and hard, but overruled. Thank you very much. Go ahead, please.
Let me ask you this, Mr. Kilbane, would you expect that the defense attorneys, having received this email and text message, would inform their clients of the contents?
Overruled. Excuse me, sustained. I've screwed up the ruling. I don't care. It's irrelevant. Move on. Next question. There's no suggestion here that defense counsel acted improperly in consulting with their clients about what occurred. There's no contention, so let's just move on.
Well, I think it's relevant, Judge. The issue, if I can address it.
What's it relevant to?
The relevance here is we have to show that there was an intent to cause a mistrial. Right? So in establishing that, I think we need to get out the facts of what happened if this was disclosed. What do they think was going to happen? And it's the judge and the prosecutors. They disclose this. Now we're in a situation, we're put on notice, we have to do something.
So, I read the cases that you gentlemen put in your briefs as that you were coerced into seeking a pretrial. And I know there's some intention that the action here by the court and or the state was to put you in that position, right?
Correct.
So your point is they had to know you would be talking to your clients about
Correct.
that?
Right.
Okay. So is that really a serious dispute?
We're starting fresh here in this motion. I think
Okay.
it needs to be established.
Okay, go ahead and ask the question. It's taking too long to fuss about it.
Okay.
Thank you.
Having disclosed this to defense attorneys, did you expect them to notify their clients of this communication, this text message and email?
I didn't make a conclusion as to what the defense attorneys were going to do. Our conversations between myself, Kevin Filiatro, and Ben McNair was, this was a communication made by the court, defense needs to see it, and that's all we did. I didn't ever think about what you were going to do with that information.
Or you made party to, or had a discussion with Kevin Filiatro about an email that he sent to me on March 11th at 3:19 p.m.?
I don't recall.
The name's on the email. It's marked.
You need to what?
I need to have it marked.
Okay, please.
Approach the witness, Judge.
Sir.
Mr. Gillian, handing this book marked as Defense Exhibit B. I'm going to direct your attention to this. Can you identify what this document is?
This is a email on Saturday, March 11th, 2023 at 3:19 p.m. Addressed to you as well as all the parties in the case. That was drafted and sent by Kevin Filiatro.
Okay, and were you included on that email?
I was.
Okay. And did not Mr. Filiatro say, fully expect all of you to share this information with your clients?
He did.
Was there an expectation that a motion for mistrial would be made by defense attorneys after Friday evening?
On Friday evening,
Yeah.
I did not have an expectation of what was going to happen after that. I didn't know what was going to happen.
Okay, how about Monday morning? The following
Monday morning, I knew that that defense counsel, at least for one of the parties, was going to ask for a mistrial. Yes, I knew that.
In presenting the state's case in this trial during that first week before the mistrial was granted, do you recall that there was a situation where Mr. Filiatro stood up and made a proffer for Judge Russo as to what the evidence would be in this case so that the judge would allow statements of co-conspirators in?
I do recall Kevin Filiatro making a proffer to the court about the independent evidence establishing the conspiracy. Yes.
Okay, and in that proffer, it was not an evidentiary proffer. There were no witnesses called. It was just Kevin Filiatro speaking on the record, correct?
It was Kevin Filiatro telling the court what we anticipated the evidence was going to be that establishes the independent evidence which establishes the conspiracy. Yes.
Okay, so a proffer without testimony is nothing more than an opening statement. It's not evidence, is it?
I wouldn't call it an opening statement, but it's not evidence, correct?
Okay. Was there any concern after having had the communications with Ms. Dunham, including the two communications with you and then that text message, that there was a concern of an appellate issue approaching in this case?
Can you clarify that?
Yeah, was there concern by the prosecutors that there was going to be an appellate issue over the admission of the co-conspirator statements?
Were we concerned about
Yeah.
an appellate
Your Honor,
issue?
objection. I mean, these are privileged communications.
Well, I'm going to sustain the objection on a different ground. I'm sure you'll accept it. Let's move on. I think we all generally know the Court of Appeals is out there.
Having read that text message and the communications that Ms. Dunham had with you, did it appear to you, or did the thought cross your mind that perhaps Judge Russo had changed his mind about the admission?
Objection.
And your grounds is what?
He's asking what Judge Russo thought.
Well,
How
I
can
thought
he know what Judge
no,
Russo
I
thought?
think he said, did it cross your mind, Mr. Gilbane, that the judge had changed his mind? Okay?
So he's asking, if he's asking what Mr. Kilbane thought, that's one thing. I'm not objecting to that. If he's asking what Judge Russo thought, I would object.
I think he did. He said, did it cross your mind, Mr. Gilbane, that Judge Russo had changed his mind? That's what I thought he said.
I did.
Can I answer this question?
Please.
Yes, it did cross my mind. Yes.
After these events happened, we took communications with you and that text message. Did you or any of your fellow prosecutors have any conversation with the judge or Ms. Dunham saying this issue really needs to be put on the record, this whole issue?
After we received the text message?
Yeah.
We didn't have it.
Let me,
During what time frame?
let me make it, exhibit A. Exhibit A, direct your attention to the bottom of page 2.
Okay.
Mr. Filiatro did respond to Ms. Dunham's text message, did he not?
He did.
And the response, in effect, was this needed to be discussed with all the parties, right? President.
That's a fair characterization, yes.
Yeah. Okay. So at least Ms. Dunham was put on notice that this is something that needed to be discussed with everybody, correct? You don't know if she got that back to the judge or not?
That was the state's position, yes.
I have nothing further this time.
Thank you very much. Mr. Martin, Mr. Schlackett, Mr. Hilo, Mr. McDonald, anything further?
Not on behalf of Ms. Smith, Your Honor, thank you.
No, you're
Okay. And you probably don't need to cross-examine, do you?
Yes, I do.
Okay, go ahead, Mr. Pointer.
Thank you. Mr. Kilbane. The first communication, Mr. Fallon asked you about that first communication where Ms. Dunham asked you something and then you replied. Do you remember that question?
Yes.
All right. What information was she looking for?
She wanted to know if the state was going to call any witnesses to establish independent proof of the conspiracy prior to any co-conspirator testimony.
Did you give her a substantive answer to that question?
No.
When you came back to the trial table, well, first off, describe what was happening in the trial when this communication from her to you occurred.
Well, we had already called some witnesses. I don't know if it was a lunch break or a break in general. I was sitting by myself with Kristen McCaskill or no other prosecutors at the table, and that's when she approached me and asked me to step out into the hallway.
When there's a break like that during a trial, how would you characterize that break for prosecutors when you're still trying to put on other witnesses in the case?
It's not great.
What do you mean by that?
Well, we're still trying to coordinate with witnesses, calling witnesses, seeing if our next witness is even there, outside the hallway, ready to go. If there's a witness coming up, I would typically be reviewing statements, getting exhibits ready, marking exhibits. So it's not just me sitting there, or any of us sitting there, it's preparing for testimony so that the trial moves as smoothly as possible.
And so I just asked you if you gave a substantive answer to Ms. Dunham's question. And what was your answer?
No.
Okay. Did you ever give any type of substantive answer to any of those questions from her?
No.
When you came back to the trial table, did you tell Mr. McNair and myself, and Special Agent McCaskill, what had just happened?
I did.
Did I have a reaction to it?
You did.
What was my reaction?
You were visibly upset, and you told me to ignore it and that we don't engage in that bullshit.
And so, is that one of the reasons why you never answered any of those questions?
One of the reasons, yes.
How about any other reasons?
I just didn't think it was appropriate to answer that question outside the presence of defense counsel.
So then, the next day, when the second question is asked of you, did you answer that substantively?
My only response was no.
Okay. That night,
Yes.
did that question alter the way that the state presented evidence in this case?
Absolutely not.
Did that question come into play at all when deciding who was going to testify next?
No.
The next day, on Friday night, let me step back. During this trial, on Thursday and Friday, had the state called any of the co-defendants yet?
No.
Who was the first co-defendant who was going to testify?
Bertria Williams.
And when was she going to testify?
She was going to be our third witness on Monday morning.
Okay. Without these questions, did we understand that we needed to show independent proof of this conspiracy, regardless of any questions from the bailiff to you?
Can you repeat that?
Yes. Was the state aware of its obligation to show independent proof of the conspiracy in this case?
Yes.
Yes. Regardless of any questions that Ms. Dunham asked you?
Correct.
Okay. On Thursday, did we call Turquoise Jackson to testify?
I don't recall if we called her on Thursday, but I do know that Turquoise Jackson had already testified prior to me getting that first communication from Kathleen.
Okay. All right. And did you feel that Turquoise Jackson had provided testimony regarding independent proof of the conspiracy for any of these defendants?
I did.
Which one?
Hakeem Shomo.
All right. Let's go to Friday night. Independent of the question from Kathleen Dunham to you on Thursday, who was the state calling to testify on Friday?
The state, who did we anticipate calling on Friday?
Well, here, let me ask you this one. Did we call an individual named Jordan Mack to testify?
Yes. Yes.
And when did she testify?
She was the last witness on Friday.
All right. And did she provide independent proof of the conspiracy against any of these defendants?
She did.
Which one?
Anthony Bryant.
Okay. And was the decision to call Jordan Mack on Friday done independently of any question that Kathleen Dunham asked you?
No.
Are you sure? Let me ask that
Can you
again.
repeat that question?
Was the decision to call Jordan Mack to testify on Friday, was that decision made independent of anything Kathleen Dunham asked you?
We had planned on calling Jordan Mack on Friday regardless of whatever Kathleen Dunham was telling us.
Okay.
That was the plan all along.
Right, okay. And now I want to talk about,
Can I just interject a small teeny point?
yes,
So you're saying that the Turquoise Jackson and Jordan Mack witnesses were not there to offer the testimony of co-defendants, but rather to offer independent evidence of the conspiracy?
correct.
Thank you.
Correct, thank you. Here, is that one of the things that each of those witnesses did?
Yes.
Do you have that text message from Kathleen Dunham in front of you from Friday night?
I do.
Okay. Mr. Kilbane, did you feel there was a difference between the communications from Ms. Dunham to you on the two other questions that were made before this text message?
I did.
What's the difference How did you feel the difference was between those things?
Well, Thursday was a very general question regarding the case in general. Friday, we get a text that's more specific in terms of the fact that it specifically names a co-defendant on trial by name. And at the point that we were at in the testimony, we had Turquoise Jackson who testified that we believed wrapped Hakeem-Shomo into the conspiracy. Jordan Mack, who testified on Friday, wrapped Anthony Bryant into the conspiracy. And after now those two witnesses have testified and wrapped 2 of the 3 defendants into the conspiracy, this text message is more specific, asking about Brittany Smith in the conspiracy.
Okay, thank you. Now, that text message was sent at 6:10 p.m. on Friday?
Yes.
Okay, I want you to back up a little bit.
Okay.
Do you recall anything about, that we put on the record, about who we intended to call as witnesses on Monday morning?
We told the court on the record that we were calling Corlasia Brennan, as, I believe, our first witness on Monday.
Okay. And did we expect Corlasia Brennan to wrap any of these 3 into the conspiracy independent of co-conspirator statements?
Yes.
Who did we expect Corlasia Brennan to wrap into this conspiracy independent of co-conspirator statements?
Brittany Smith.
Is that the same defendant that the text message mentions?
Yes.
Was the text message sent to us before or after we had said Corlasia Brennan was testifying on Monday?
This text message was sent after we put that on the record.
So is it fair to say we had already decided to call Corlasia Brennan on Monday morning, and that to our thinking that was going to wrap Brittany Smith into this conspiracy independently of co-conspirator statements?
Correct. We had decided to call Corlasia Brennan as a witness on Monday morning, independent of anyone telling us who to call or asking us or inquiring us on who we were calling. The plan was to call Corlasia Brennan as a witness first thing Monday morning.
And in fact, we said that on the record Friday before we left court.
That's correct.
And it's after that when this text message comes to us.
Correct.
Did we ask Judge Russo for help in prosecuting this case?
We never asked Judge Russo or Kathleen Dunham for help.
Did we want Judge Russo's help in prosecuting this case?
No.
Did we want anyone's help from the court in prosecuting this case?
No.
Let's talk about this response. Who wrote this response to Kathleen Dunham's text?
You did, Kevin Filiatro.
I'd like you to please read it in the record.
Oh, please, it's in the record. We can all read English. It's an exhibit. There's no dispute about it. In the interest of time, proceed to the next question.
Okay. That response, was that sent 1 minute after Kathleen Dunham sent the original question?
Yes, it was immediately sent.
This response, is this a substantive answer to anything Kathleen Dunham is asking us?
No.
So this is sent, in this, we received a text message at 6:10 p.m. That was Friday night, correct?
Correct.
Was your understanding that this was Friday? Each of us had perhaps plans with their families and left the building at some point.
When I got this text message, I was picking up pizza for my kids and wife.
And do you have the email in front of you still that was sent at 11:27 p.m. that night?
Yes.
That email was that sent the same day as this text message that we received from Ms. O?
It was.
Is that email an accurate reflection of the number of times that we received unrequested communications from the bailiff in this case?
Yes.
Let's talk about the weekend. Between that time frame, 6:10 p.m., my response at 6:11 p.m., and my email at 11:27 p.m., were you doing things with your family that night?
Yes.
Did you understand that I was doing things with my family?
You were.
But this was discussed and sent to all defense counsel before the end of the day.
It was.
Did you speak with any of the defense lawyers that weekend about what their potential plans were on Monday morning?
Me personally? No, I did not.
Were you aware whether I had spoken with defense counsel about their plans that week? If you don't. If you don't.
I don't recall.
That's fine.
I don't know.
Let me ask it this way. Monday morning,
Yeah,
did we have witnesses ready to go?
we did.
Was Corlasia Brennan here?
She was here.
And were we prepared to proceed and call witnesses the same way we had decided to do Friday, the way we put it on the record, before we ever got this text message we never asked for?
Yes.
Mr. Cobain, did the state of Ohio want a mistrial in this case?
Absolutely not.
When court ended on Friday, how did you feel about how testimony was going?
Objection.
Overruled, we'll permit that question.
We were thrilled with how the evidence was coming in front of the jury, and specifically, we were thrilled with how Jordan Mack testified on Friday as the last witness before the jury went home for the weekend.
Did the state of Ohio question this way. Do you still have the second email up there? Did you have another second email that you used?
You didn't give me a copy of these. I think it's Defense Exhibit B.
Yeah.
I have defense exhibit B, yes.
Okay, all right. All right. Defense Exhibit B. I'd like you to go to the middle of that first page there. Is there an email from Mr. Fallon that I'm responding to?
Yes.
Okay. Please read the first sentence of Mr. Fallon's email to me.
Kevin, thanks for your professional response to the text from Kathleen.
Okay. Now I'd like you to go up to take a look at my response to what Mr. Fallon said.
Okay.
I'm sorry, step back for a second. After writing that, does Mr. Fallon say he's going to talk about this with his clients?
He does.
Okay. All right. Now going to my response to Mr. Fallon's email, up to the top of that page.
Okay.
Do I state whether that we have talked to Judge Russo or his bailiff after the text message?
You indicate that we have not had any communication with her or anyone with the court since my response to her text.
Okay. So, is it fair to say, walking in Monday morning, we had no idea whether a mistrial was going to be granted in this case?
We did not know if it was going to be granted.
And were we prepared to proceed with witnesses in the event that the defense attorneys did not ask for a mistrial?
We were.
Were we prepared to proceed with witnesses in the event that they asked for a mistrial and it was denied?
We were prepared to proceed.
Let's talk about Monday morning for a second. When we came in Monday morning, did you see all of the same defense lawyers that are in the courtroom here that morning?
I did.
And did there come a time where all of the defense attorneys, as well as yourself, myself, and Mr. McNair, were in Judge Russo's chambers?
Yes.
Is that where the defense lawyers raised with Judge Russo any problems they had with the text messages and what they were asking the court to do?
Yes, they disclosed, one of the defense attorneys, I don't recall who, disclosed to the judge that they were aware that a text message was sent on Friday evening, that the state of Ohio disclosed that text message, and that they were going to be asking for a mistrial. And all the defense attorneys were in agreement with that.
Okay. And were we prepared to proceed with witnesses no matter what happened?
Yes.
Did we want a mistrial in this case?
Absolutely not.
Did we need a mistrial in this case?
No, this is the last thing we wanted.
Why is this the last thing we wanted?
Well, we asked the court if we could try all three defendants together. That was granted. We got to try all three defendants together. We got a favorable ruling on the statements of co-conspirators. Turquoise Jackson had testified as one of our first witnesses who specifically ties Hakeem Shomo into the initial kidnapping of Tashara Harris and Turquoise Jackson, which ultimately led to the kidnapping of Alishah Pointer. We had gotten testimony from Jordan Mack on Friday evening, which ties Anthony Bryant to one of the murder weapons in the case. We had a ballistics expert who was going to testify prior to Brittany Williams testifying that was going to tie the shell casings found at the scene where they left her body to the firearm that was connected to Anthony Bryant. We were absolutely thrilled with where this case was going and how it was being presented to the jury.
That's all gone now, isn't it?
Correct.
Did we engage with the court in the things they were asking for?
We never did and we never wanted to.
Now, Mr. Cobain, is it uncertain when or if we will get to try this case?
That's correct.
Any further questions based on Mr. Filiatro's questions?
Yes, Your Honor. Cobain, Mr. Filiatro used the term bullshit.
Yes.
What did he mean by that you understood?
He doesn't interpret for Mr. Filiatro. Next
He
question.
answered the question, you seem to know what that.
Let's have the next question, please.
Did you know what Mr. Filiatro was referring to?
We're not engaging with the court on ex parte communications.
Okay.
That's how I understood it to be.
Okay. And as it relates to the conspiracy, the only conspiracy count that involves Mr. Bryant is count 16 in the indictment. Recall that?
I do.
Okay. And that conspiracy referred only to the crime of kidnapping, did it not?
Correct.
Not murder.
It referred to kidnapping, and the theory of the state's case was your client had shot Alishah Pointer multiple times, which is to me, the definition of kidnapping, and left her body there.
Okay, well, count 16 refers to with purpose to commit or promote or facilitate the commission of kidnapping,
Correct.
not murder. That was not contained in the indictment.
That's correct, but that's also, the conspiracy is also a predicate for the murder B charge, in which Mr. Bryant is also charged with.
Okay, let me ask you something about the mistrial being granted. It's been 3 weeks plus, something like that.
Since the mistrial was granted?
Yeah, right? Or more than that.
It was, I believe,
March
March
13th?
I believe it was March 13th, yes.
All right, so it's been
17
Seven.
plus 30, 47 days.
thereabouts. During that period of time, has the prosecution subpoenaed any more evidence, records, anything like that?
Objection.
Sustained.
I'm trying to determine whether or not, because they said that they didn't want a mistrial, or they used this time to improve their position. And I think that's a relevant question they ask if they continue to get information.
I respectfully disagree.
Right, nothing further.
Okay, thank you. Anything further, Mr. Filiatro? I forgot all about you, Mr. Sackett. My apologies.
Very briefly, Mr. Kilbane, you testified that you believe Jackson and Mack provided independent testimony of a conspiracy as to Brian and Shomo.
Correct.
But neither one of them provided any independent evidence of a conspiracy against Brittany Smith, did they, yes or no?
No.
And the text message sent from the court to your office was, before you call Portria Williams to testify as a co-conspirator, are you going to show any independent proof of a conspiracy as to Smith, correct?
That was a communication that was made, yes.
Okay. Would you agree with me that there's a basis for a mistrial based on prosecutorial misconduct as opposed to a court misconduct? Do you understand the difference?
I would like you to clarify the question if you can.
Sure. Would you agree with me, in your experience as a major trial prosecutor, that there could be a mistrial based upon, a request for a mistrial based upon prosecutorial misconduct?
There can be a request for a mistrial based on prosecutorial misconduct, yes.
And can there be a request for a mistrial based upon a court's misconduct? Or don't you know?
I don't know.
Okay. Do you think it would, let me just ask you this, Mr. Cobain. Let's say that I was cross-examining one of your witnesses, one of the state's witnesses, and Judge Russo texts me during the trial and says, don't ask him this, why don't you ask him that? And didn't include you on that text. You think that would have been appropriate?
No.
That'd be an improper ex parte communication, correct?
It would be an ex-parte communication, yes.
And it would be improper, wouldn't it?
I believe so, yes. That would be
Whether
proper.
I asked for it or whether I didn't ask for it, correct?
Correct.
Objection, Your Honor. He's asking for counsel's opinion on something. It goes beyond the scope of these proceedings. The
Yeah.
issue,
It's also time consuming. Could we move along, please?
I will move along, Your Honor.
Thank you.
Thank you, Your Honor. Sorry to waste the court's time.
No, I didn't say you were wasting my time, but just that your point was obvious and well taken, and we could move on, that's all.
Thank you, Your Honor.
Mr. Heidel, Mr.
No
McDonald?
further questions, Your Honor.
No, nothing, Your Honor.
Any further questions of this witness? Going once, going twice?
Yes, response to some of Mr. Fowler's questions, Judge?
Sure, go ahead.
Thank you. Mr. Kilbane, Mr. Fallon asked you about the conspiracy charge against Mr. Bryant only goes to kidnapping. Do you remember that question?
Yes.
Is that charge, conspiracy, alleged against Mr. Bryant, the basis for a murder B count against him?
Yes.
With regard to Mr. Schlackett's questions, asking about prosecutorial misconduct, remember those questions?
Yes.
And judicial misconduct.
Yes.
Okay. Did the state respond to any of the court's questions about when witnesses were being called that were asked only of you or us without the defense lawyers there?
We never answered those questions.
And when a message was sent indicating one of the defendants by name specifically, was that communication turned over to all defense counsel?
It was.
Nothing further.
Anything further, defense counsel?
No, Your Honor.
Okay, you can step down. Thank you, Mr. Heidel. I didn't
Yes, Your Honor.
Any objection?
No objection.
They'll be admitted then, and I'll give them to the court reporter. So, I was remiss at the beginning of our proceedings to acknowledge that the state of Ohio did provide access to this hearing for the convenience of the decedent, Ms. Pointer's family members, and so they are participating and observing and listening to this hearing by Zoom technology, and that, of course, is an important way to satisfy Marcy's law. They've been had that access to the proceedings since we began, and I neglected to state that at the beginning. So, the other thing that I looked for, gentlemen, on the court's docket, and I did not immediately see it, was the court's ruling on this matter of accepting a proffer of the evidence of a conspiracy instead of requiring independent evidence of a conspiracy. Can anyone point that out to me, or explain how that was provided?
Yes, Judge, thank you. Your Honor, this issue was raised by all defense counsel several times. This was one of the main issues in the case, I think it's fair to say. It was during voir dire, jury selection was not completed yet, when Judge Russo came in and addressed this on the record. A transcript has been provided to all of the attorneys by our court reporter, and the state can, any one of us can give that to you.
Oh, I have it.
Oh, okay, all right.
The court reporter forwarded to me your proffer. What I was looking for was either something in a transcript or in an entry that, in which the judge said he would accept your proffer of your expected evidence of the conspiracy in lieu of requiring independent proof of the conspiracy before these defendants, the co-defendant statements were admitted.
And I think the court may, I don't want the court to get the wrong impression of what happened. First off, the court, Judge Russo mentioned this, I believe, the night before leaving, mentioned the issue on the record and had some discussion, and then the next day he comes in and says, I've looked at these cases. I can't remember exactly, but all of this is on the record, where he discussed certain cases that he had looked at, case law on the issue of conspiracy, and felt that he could do this one of a few different ways. And the way I took the proffer, the opportunity to proffer evidence to the court, was to show the court as a threshold matter what the state would prove. Just a snapshot of what we would prove independently of any statements, showing that each of these three defendants' existence, the existence of, and their own activities in furtherance of the conspiracy, just so he can be satisfied that by the end of the trial, all of it would be proven, and as a threshold matter, he could say, yes, the state will prove this, and by the end of the trial, I will have had enough evidence of independently of the conspiracy such that admission of co-conspirator statements is proper during the trial. As the court's aware, there's no way to prove all of these things exactly before you've got witnesses coming on to say what people said. To do it that way would be to require the state to call and then recall witnesses, perhaps even more than once during a trial. Frankly, it's absurd, and the evidence rules do not require it. And that's one thing.
I mean, the federal rules don't require
I don't think Ohio's evidence rules require it either. But look, you're touching on.
You don't interpret our language on independent proof of conspiracy to require that exactitude.
No, that's not what I'm saying.
Okay.
What I'm saying is the rules of evidence don't require that. They allow for threshold findings to be made by the court such that admission of evidence is proper on the idea that you've proven some of what I need. After this witness testifies, in other witnesses, you will prove the rest of what I need. That's what I'm saying. Such that independent proof, which is required by the rules and by statute, can be done throughout the course of a trial. This is one of the things Judge Russo made a finding of. And I'll just be up front here. This is one of the things defense counsel objected to. There was an argument about order of witnesses and how much had needed to be proven before certain witnesses could testify to certain things. And so Judge Russo looked at cases, made a ruling, and proceeded. So that's all in transcript. I don't believe there is a journal entry that details this, but I think the transcript, you've got the proffer, my proffer part of it. There is more transcript that deals with this, with what Judge Russo was thinking outside of what I said. Does that make sense?
Yes, and I remember Mr. Slackett saying, and we were not on the record when he said it, that the defense counsel had objected to Judge Russo's ruling that the state could satisfy their obligation to prove a conspiracy by simply proffering it in the record, and I think Mr. Slackett referred to it as proving it by opening statement or something like that. Or maybe proving it by proffer.
Yeah.
So I take it that defense counsel wanted a more traditional following of 801, and that upon independent proof of the conspiracy.
So the defense objected to many things regarding co-conspirator testimony. The state made this proffer, but I understood it to be a preview of what the court might need to make a threshold finding. The state always planned on bringing in independent evidence of each of these defendants' participation in the conspiracy and the conspiracy itself. In that proffer, I only touch upon the numerous text messages which went back and forth between co-defendants and each other. I'm sorry, these defendants and co-defendants, these defendants and other people. There's a bevy of it. And I think what comes clear in that proffer is there was much more than what I said, but I wanted to give the court enough so that the court could be satisfied, again, as a threshold matter, that this would be proven throughout the course of the trial, such that the court could be confident in making a finding that the state will prove this, such that admission of co-conspirator statements is a proper thing to do in this trial.
Well, for one thing, your proffer established that this was a very convoluted, complex, detailed sequence of events that had to be followed in order to understand the proof of the case. So I understood from something I read, I think from Mr. Fallon's filing, that the court was willing to follow both the Ohio Supreme Court's ruling in the Carter case as well as the Jelowitz case, right?
I misunderstood your question. Are you saying that's what Mr. Fallon is saying, or?
Mr. Fallon's brief, which was a reply brief to your brief in opposition, was critical of the trial courts being willing to rely on two Ohio Supreme Court decisions in this area on independent proof of conspiracy. One being the Carter case and then the more recent Jelowitz case.
Sure. Defense counsel objected to the way Judge Russo proceeded. There's no question about that. What I was arguing on the record in this case at that time was defense counsel, their objections were making it seem as though conspiracy was this unclimbable mountain that we would never achieve to prove all of this. And what I wanted to do with this proffer was to show there was plenty of evidence outside of a witness coming in here and pointing at these defendants and saying, this is what he said, that's how I know he's in the conspiracy. This is what she said, that's how I know she's in the conspiracy. We didn't need to rely on that to prove it, to prove the existence of the conspiracy and to prove each of their involvement in it. I encourage the court to look at the indictment in this case. Each count of conspiracy for each defendant outlines the conspiracy itself, as well as their own specific overt acts that each of them did in furtherance of the conspiracy. 3 defendants pled guilty to their counts of conspiracy, admitting as a factual matter that they did those things. Portria Williams, Destiny Henderson, and Nathaniel Pope. The state was prepared and remains prepared to show what's on the indictment for each of these 3 defendants remaining for trial, what they did in furtherance of the conspiracy themselves. All right? There was always a dispute from defense about how the court should go about this. This goes hand in hand with each of these defendants' motions for separate trial. They all wanted a separate trial because they all had arguments about defendants coming in here, witnesses coming in here, saying what everybody did as part of this conspiracy in a trial for 3 instead of just 1. Always objections. There was never agreement. And so Judge Russo made a call, pursuant to case law, the way he read it, and that's all contained in the transcript.
Thank you. So, the way I read 801 in its provision for requiring independent proof of conspiracy before certain evidence can be introduced, it presents both a timing issue and a foundation. So would there have been anything wrong at the close of Friday, for example, if Judge Russo had sent the jury home and kept everybody else in the courtroom and said, so what's the state's position? Have you presented independent evidence of a conspiracy that ties this particular defendant to the crimes?
Would there have been anything wrong with asking that question with all the lawyers present?
Right.
No, nothing wrong with that, in my opinion.
And so would there have been anything wrong, in your opinion, if the question was, is the state of Ohio presenting any witnesses let me track the language of the email, or excuse me, the text. Would there be anything wrong with having all counsel present and asking the state, do you have any witnesses you're going to be calling prior to calling Portia or Portria Williams that will tie Defendant Smith to the conspiracy?
I don't think there would have been anything wrong with that, so long as that question was asked in front of all the lawyers.
Well, that was my premise.
Yeah. I don't know whether defense counsel would have objected to a question like that, but I think that would be permissible. And frankly, I think the state had already answered that. Based on the proffer that was given, Corlasia Brennan's name is mentioned in it.
Excuse me, who?
Corlasia Brennan, the witness that the state, we said we're calling Corlasia Brennan first thing Monday. We said that before we left court on Friday.
Well, how would the court know what Brennan was going to be tested?
I said it in the proffer.
Oh, okay.
Yes, I said it in the proffer. And so that's one reason why that roadmap, the threshold, that information to make that threshold finding, that's one reason I thought it was important to do that prior to trial. So that the court would know these things. And would know that, oh, state's calling Corlasia Brennan on Monday. The state has already told me she's going to say A, B, and C.
So, yes or no, would it have been appropriate for the court in front of all the lawyers to say, Mr. Prosecutor, will you be calling any witnesses prior to calling Portria Williams? Which witnesses will tie defendant Smith to the conspiracy?
I don't think that's improper.
Excuse me?
I do not think that's improper. I think it's fine.
It's a proper question.
Yes.
And your answer might have been, well, Ms. Brennan, in fact, is going to be testifying.
That's exactly what I would have said.
Okay. So defense counsel, do you want to respond to that question the court had for the prosecutor?
Yeah, Judge, I think a couple things come into play here. Look beyond the mistrial. We're here for the double jeopardy issue. And I think we spent a little bit of time talking about the mistrial concept. Mistrial already happened. Now we're on to the double jeopardy issue. That's what this hearing is about. What you're just proposing to the prosecutor did not happen.
I know, I'm asking, but you answer my question.
If the judge had addressed everyone on the record, I wouldn't have had a problem with it. Because the judge made a ruling and he kind of was stuck with it. And he said, that's okay, you can put on the evidence in whatever order as long as you get through by the end of the case because it's only harmless error. And we objected.
And that is following Carter and most especially the gentleman's decision, right?
We're saying that decision, there's slightly different cases, different issues. We objected not only during the trial, but prior to trial, okay? I specifically filed a motion, and we had asked for separate trials, because if you have separate trials, you avoid this problem altogether. And initially, Judge Russo granted the motion for separate trials. After 3 people pled, then he said, you know what, I'm gonna just overrule myself, and we're gonna try the remaining 3 people together. So he changed his ruling on it. We went up again and complained about it and said, Judge, you know, there's going to be problems with this. We're raising this issue now before the trial starts. Rule 801, you got to have an order to these things. It's the Taniguchi case. You got to put proof on, independent proof, okay, evidence on it. Proffer is not evidence, okay? That didn't happen. So he put his proffer on, and then was calling witnesses, and apparently it would appear that the judge got a little bit concerned that maybe his ruling wasn't correct. And that's why he's reaching out through his bailiff to them and saying, hey, you're going to put some more evidence out before you call one of the co-conspirators? That's the whole problem here. So the issue that we have now...
Okay, but you can see that had that question been raised by the court, with all the lawyers present to ferret out the state's position, that would have been appropriate and proper.
That would, but it didn't happen, and that's why we had a mistrial. And now that we have the mistrial, now we're on to the double jeopardy issue, because it wasn't handled that way. Okay, so my client's sitting here being advised of, hey, the judge is emailing the prosecutors at 6 o'clock at night, directing them on how to handle their case. You really want to go forward with this judge handling your case? I have to make them aware of that. That puts us in an uncomfortable position. And it puts a defendant in a pretty uncomfortable position if the judge is coaching the prosecutors from the sideline. And that's the issue that we have here. That's why we're on a double jeopardy motion.
Okay, so at some point, I presume that you folks are going to explain to the court why you call this coaching. Because you know, at some point in your filings, you call it coaching. At other points, you say the judge is trying to force the defendant to ask for a mistrial. And some point, I think I read something about the court signaling to the prosecutor what they ought to be doing, or they were facing something, or there was some kind of signal involved. I mean, there's a number of different allegations of what the judge's motives were.
Right.
Well, I mean, at some point, is somebody going to explain that to me?
Yeah, that's why we subpoenaed the judge, so we can ask him what he was doing. Okay, that's why we subpoenaed his bailiff, so we can ask those questions.
Well, but you went ahead and filed motions, and you didn't wait for any testimony to start characterizing what the judge's conduct in this case represented. You came right out in your filings, and you started saying that the judge was doing this, the judge was doing that.
I think that's a fair interpretation of the text and the conversation.
Okay,
The problem
so
that we
you
have-
don't need any testimony to start accusing the judge of this inappropriate conduct. I'm just simply trying, when I read this, I don't think coaching. Maybe you've got some argument that I should see that as coaching.
Okay, maybe I'll try and explain it this way. The judge made a ruling, and the prosecutors relied on that ruling, which was that it was okay to use a proffer. Okay, they didn't have to present evidence, independent evidence. It was okay to use a proffer. So that's what they did. They put a proffer on it with no evidentiary basis, just the prosecutor explaining the case.
Wait a minute. They put on a proffer of what they expected their evidence to be, right?
Yeah, which is not evidence.
Right. And then they were still planning, apparently from what I'm hearing here, they were still planning on putting on independent proof of conspiracy.
Perhaps they were, and it sounds like it. But that begs the question, why then is the judge reaching out just to the prosecutors through his bailiff and asking them what they're going to do? And why is he concerned about a clean record? Why would the defense be concerned about a clean record?
So help me out. Why should I look at what the judge did here and conclude he was coaching the prosecutor? He was, or as one filing said, he was trying to force a mistrial.
Because I think that's a fair reading of what happened here. I think that's a fair conclusion as to what happened here. I think that is more than fair. And as a point of this, for purpose of the motion, I did subpoena the judge and the bailiff so that we can ask those questions. And I asked that they be called as a court witness so that we can cross-examine them. I think his explanation...
Now, one more time. You filed motions to dismiss this case characterizing the court's conduct as trying to force a mistrial,
Yeah.
trying to coach the defendant, trying to help
Not
them
the
along.
defendant, the prosecution.
Excuse me, the prosecution, trying to help them along. So I'm just saying, help me out here. When I look at what happened here from the communications, how am I supposed to look at that and say, oh, look, that was the judge trying to coach the prosecutor. That was the judge trying to force a mistrial on you folks.
I think that's a fair representation. Why else would he be sending the text message through his bailiff just to the prosecution? And signaling to them that he wants a clean record. So he's asking, are you going to call more witnesses before you call that co-conspirator? So I think that's a fair representation there. That shouldn't have happened.
You agree that's a fair concern for the court to have. It's a fair concern for the court to express to the prosecutor, but he's got to do that in the context of all the trial participants.
Yes, and if he had changed his ruling and said, you know what, I thought twice about this, you're going to have to put on some independent evidence more than a proffer. That would have been fine too. But none of that happened.
So are you going to be able to point me to some record comment that Judge Russo made in which he said, as long as the state gives me this proffer of what they expect the evidence to be, I'm not going to be requiring independent evidence of the conspiracy?
Yeah, I think
You have
Kevin
something in the
explained
record?
that.
Because, there isn't, I mean, the prosecutors have indicated here today, they weren't depending on the proffer to get them out from under the requirement of 801 on giving
The
the
judge,
independent proof of the conspiracy. And if the judge is concerned about it, it sounds like he too is not depending on that proffer to meet the requirements of 801.
Judge, I think if a transcript was made of it, and I believe it was because we're all in court, I believe the proffer was on the record. Okay?
The proffer was on the record and I read it, sir.
Okay,
And
and the judge,
I was just told by Mr. Filiaggio, he thinks Judge Russo described the role of this proffer and using this requirement of independent proof of the conspiracy, that too may have been on the record. And you gentlemen received a transcript of the proceedings, did you not?
yes, we did.
So
I don't
maybe
have it with me today, but the judge,
Well,
after hearing the proffer.
We do have a date tomorrow at 3 o'clock, right? So, so if you folks could locate whatever you can find in the trial transcript about the judge explaining that.
I think it should be right after the proffer because he accepted it.
Well, the point is, I'd like to see what this record says, because what I'm hearing, and this confuses me greatly, is the prosecutors are just characterizing the proffer as nothing more than this roadmap to help the court figure out the evidence in this very convoluted and detailed scheme and sequence of events. And you, the defense side, seems to be thinking the court was only going to rely on the proffer as if it were going to be providing an independent proof of the conspiracy.
That's correct. That is correct.
Judge, can you take a look at page 308 of the transcript?
I don't have the transcript. but I
We'll
would
provide
have-
it for you tomorrow, it's right there.
Okay.
The
308.
answer to your inquiry can be addressed by page 308, we believe.
I don't believe the entire transcript was sent to me. I think it was only, I'll check because I might be wrong on that. I think it was only the proffer. Well, a lot of it, well, the court's on the record granting of the mistrial was presented to me and the proffer was given to me, but I don't think the entire transcript of the trial was given. So you don't have any other facts to offer to justify the accusation that the court was trying to force the defendants to ask for a mistrial?
Yeah, I would like to call the judge and the bailiff.
No,
get
I'm
testimony.
asking you right now if you have any other
No,
explanation
other than,
or facts to point to that would justify characterizing the court as trying to force the defendants into requesting a mistrial.
no.
Do you
I
have
haven't
any?
finished calling my witnesses, that's what I'm saying.
Well, but you might never get those witnesses, and I'm pointing out that you're already on paper characterizing the court's conduct, and you didn't have the benefit of those witnesses, so my assumption was that you must have had some basis for doing so.
Yeah, I think it's a pretty fair representation of what was said and what transpired.
So,
That's my connection. And I think in order to prove it, I have a right to call them as witnesses and inquire and get that testimony.
so do you have some facts or other arguments suggesting why the court would be motivated in forcing the defendants to ask for a mistrial?
Judge, I don't know. That's why I need to call him. I'm speculating and saying to you, the facts that we do have are the judge, through his bailiff, in my opinion, communicated in an ex parte manner, which was improper. The prosecutors brought that to our attention. We brought it to our client's attention and discussed with them the options.
okay, and they asked for and were granted a mistrial. I believe, based on what happened here and a fair reading of the evidence, is the judge made a ruling which went against the defense, which is they don't have to do anything more than put a proffer on. They don't have to put evidence on the record. Just a proffer is sufficient. And as long as they get evidence in at any point in time, that's okay. We had objected to that. I would suggest to the court that the communications that we've seen here this afternoon would indicate, and I think even Mr. Cobain indicated, that it appeared maybe the judge was changing his opinion and was trying to change his mind and was trying to cover the record to make sure the record was clean so that things would be a little bit different, so it wouldn't be an appellate issue. However, I don't think he went about it the right way. That's the whole point. That's why there's a mistrial. And I think part of what I'm trying to show is I think the court intervened because the prosecutors were not responding to him. There were a couple attempts made through the bailiff to find out what was going on. Mr. Cobain wasn't responding to it. Okay? And so the court further went after it for a third time. Okay? And I think that concern is that the record wasn't going to be clear here, and there was going to be an appellate issue, which would possibly cause the case to get reversed. So he wanted to communicate with them and maybe guide the prosecution that, hey, let's do it this way. Instead of just saying, I changed my mind, or we're going to have to do this differently. And I think as part of that, I have a right to call the judge and the bailiff to find out what was the reasoning behind the communication. Was it as we suspected? I think that's a fair thing to do in this case.
So, Mr. Filiacho, do you agree with the defense characterization that Judge Russo was going to accept only the proffer as independent evidence of the conspiracy?
I'm looking at page 295 of the transcript. This is what I will read word for word what I said to the court before I started this proffer. So what I would like to do, Judge, is proffer some evidence at this point to show that acknowledging that the case law does also suggest that it can be proven throughout the trial as well. So I went into this proffer saying, I think the court needs to know this because this is what's going to happen. Also acknowledging that the way the case law shows this to be is that the court can hear evidence as the trial goes and make a threshold finding, yes, the state's going to show a conspiracy by the end of the case, so that we're not calling the same witness 4 different times to prove certain things in a certain order to satisfy defense counsel's objections. So I acknowledge, before I even say begin the proffer, that case law shows that I can prove these things throughout the course of the trial.
Well, I today read Carter and Taniguchi, that's Taniguchi, and Jalowitz, Jalowicc. And Carter and Jalowitz are Ohio Supreme Court decisions, and they seem to make clear that the independent proof of the conspiracy does not necessarily have to precede the introduction of the co-conspirators' statements in order to bring them in as non-hearsay, right?
Yes.
And I noticed that both Carter and Jalowitz are capital death prosecutions. I mean, these are not cases where we ease the evidentiary rulings, and yet in both cases. Now, neither case, in my judgment, really dealt with the kind of convoluted facts, detailed and complex ones that you did, but notwithstanding, they were found to have, in both cases, they found some evidence was introduced as non-hearsay prior to the independent proof of the conspiracy. So that procedure has clearly been approved. I frankly can understand the sensitivity the defendants have to using Carter and Jalowitz, because when you have a very convoluted, detailed chain of events, 3 different defendants, multiple people making the connection, it might be easy at the end of the day to lose track of whether you really have substantive evidence or hearsay. So I think this is a difficult case to apply the holdings of Carter and Jalowitz, but there you have it. That's Ohio law. Anything else you wanted to provide, Mr.?
No, I mean, I would like to reserve an ability to make an argument at some point. I don't know what's happening with, whether more witnesses are going to testify or not, but I would like to reserve the right to argue how double jeopardy does not apply to this case. So whenever evidence is done, we'd like to have that ability.
Again, defense counsel, I asked Mr. Fallon and I received his answer, but for example, in defendant Smith's motion to dismiss, it says the conduct of the trial court was done with the expectation that if the information was disclosed, it would goad and require the defendant to request a mistrial. So, Mr. Martin, Mr. Schlackett, I mean, is there some evidence you can point to that would justify that allegation in your motion?
Judge, yeah, that motion, that allegation was not frivolously made.
I didn't say it was frivolous. I'm asking for I'm trying to read these texts and say where's the evidence that somebody was trying to goad and require you to request a mistrial?
If I may, Your Honor, speak plainly. The prosecutor presents their case, the defense lawyers defend the cases, and the judge are in neutral umpires.
I've heard that before. Go ahead.
Okay? This judge, in this particular case, I have the utmost respect for Judge Russo, but he went from being an umpire to a player or a managing coach. Sorry to bother you, but Judge wanted me to text you and see if any of the witnesses prior to Williams will tie in Smith to the conspiracy. That's no different.
Sir, I have no problem with the impropriety. I understand the ex-parte, but
Okay.
I'm trying to figure out what about what you just read would cause me to conclude, there's the trial judge is goading and requiring the defendant to request a mistrial.
Judge, when a judge sends that type of text message, surreptitiously, clandestinely, ex parte, only to the prosecutors, and the judge, being as intelligent as Judge Russo is, has to know that if that information is disclosed, the defendants will be forced into no option whatsoever except to say, the judge isn't fair to us, we want a mistrial. That is, if you can show me a better, I don't mean you, I'm saying rhetorically,
Yeah.
to show a better example of where you're goaded or forced into making the option of a mistrial, I'd like to see it. We had no option but to opt for the mistrial request due to the misconduct of the court. That is a direct misconduct. That is, I don't want to get into it on the record, Your Honor. I mean, I have the utmost respect for Judge Russo, but the canons of ethics don't permit it, of judicial conduct. He can't do what he did.
But I don't understand how you folks go from, he made an improper ex parte communication to the prosecutors, and that was evidence of him trying to force a mistrial.
Well, what's the only expectation? What's the end result of that conduct? That is going to get disclosed because we have very ethical professional prosecutors. It got disclosed, we shared it with our clients, and here we are with a mistrial and now a double jeopardy issue. That's the only way it could end. Everybody knows it. We couldn't just ignore it. We couldn't just wipe that away and not tell our clients.
I don't think anyone would suggest that you would not disclose that to your clients, but I don't see how that's requesting a mistrial.
It forced us to request a mistrial because the usual...
The misconduct in your mind forced the mistrial. But you write this up like the judge in his mind caused the bailiff to send this communication with a view that you folks would learn about it and ask for a mistrial.
Well, I don't think that was his intent, because I'm not sure he knew we were going to find out about it, because there were other, as you heard testimony today, there were other ex-parte communications that we weren't even told about.
And do you, like Mr. Fallon, agree that there would have been nothing wrong with Judge Russo raising the issue about whether there be any witnesses before Ms. Williams testified that would tie Ms. Smith to the conspiracy, if that issue was presented in the presence of all the lawyers?
I most respectfully do disagree with Mr. Fallon's perspective on that, Your Honor. That is not a court's job. The court can't help the prosecutor put on their case, nor can they say to the defendant, don't claim alibi, claim misidentification. The judge can't do that. He can't help them to say, if he's got concerns about his ruling, whether he has that or not, I don't even care. If he's got concerns about how the evidence is coming in, if he's worried about, well, we got to show this independent proof of the conspiracy before we can introduce the hearsay testimony, then he has to just listen to it. They don't help the general felony prosecutors if they don't know what they're doing.
Well, but let's talk about this, Mr. Fallon, or Mr. Schlesinger, because I've given this an awful lot of thought.
I know you do, Judge.
So this matter of whether there's been independent evidence of the conspiracy tying Ms. Smith to the crimes is a foundational subject, foundational matter that has to be produced before the prosecutor can draw out Ms. Smith's statements with the co-conspirators, right?
Yes.
So it's foundational, right?
It is.
So isn't that the judge's job to worry about whether a foundation has been laid for the admission of evidence?
No, what the judge's job to do, most respectfully, Your Honor, is if the state doesn't lay that independent proof, or what you're going to characterize as a foundation, and they call the witness and they then try to introduce hearsay, objection sustained. That's what happens.
But Mr. Slackett, the court deals in foundation all the time. If a question is asked of a witness, the other counsel sings out, objection, no foundation. The court can have a sidebar. It can delve into the issue about whether there's been a proper foundation laid. That's the job of the judge to worry about foundations.
That's when you're on the record with all parties present.
I'm talking about, excuse me, don't change the facts. You said that the court couldn't worry about foundation.
I
But
don't think...
the courts are in the foundation. That is something the court has to worry about. And it would have been appropriate, it seems to me, for the court to say in the presence of all counsel, Mr. Prosecutor, is it your position that you've laid an independent, presented independent proof of the conspiracy tying Ms. Smith to it?
Well, that's a good intellectual discussion, Your Honor, but that's not what happened.
Excuse me, that's not my point. I know what happened, but you're trying to say to me the court can't get into the business of, does the state think they've introduced their foundation?
I don't think the state's, that's the state's, I don't think, I'm sorry, I misspoke. I don't think that's a judge's job. The judge is just supposed to listen to the evidence and...
It's the potted plant theory of... I'm sorry, Mr. Slackett, it just seems to me that courts have to worry about foundation all the time. A witness can be on the stand testifying, and if there is a question posed, it is appropriate for the court to point out that there's been no foundation laid for that witness to have that information.
I understand that's when there's an objection and the court says you
No,
can't get
even
into that.
before there's an objection.
Well,
Every time a question is asked of a witness, there is a foundational question that the court can stop the questioning right there, whether there's any reason to believe the witness would know the answer to the question. In other words, whether the witness would have any first-hand knowledge.
I understand.
So, but it seems to me that this question about, do you have any witnesses, before Williams testifies, is the same thing as saying, does the state think they've laid their foundation yet? And that's, and it strikes me as especially fair question when you have such a convoluted proffer of, here's what the evidence is going to be.
Your Honor, we, at least on behalf of Brittany Smith, we stand by the proposition that the court changed roles from being a neutral umpire to being a coaching player. That's all.
I'm not here to disagree with that characterization, and you've helped me understand why you say the judge was goading you into a mistrial. What you're really saying is the court had to know that by forcing those disclosures from the prosecutors, it was risking the defense counsel would find out and they would request a mistrial.
You say it more artfully than I, Your Honor. Thank you.
But I didn't really follow what you folks put in the brief. So anything else you wanted to observe? We're going to have another session tomorrow. I think I'll make a decision relative to whether or not I'm going to quash the subpoenas or not, and I'll do that tomorrow, and you'll get announcement of the decision before the 3 o'clock hearing, so we'll have at least one more session, and somebody will bring me that transcript to read. Mr. McDonald, Mr. Hilo, anything further?
Judge, just one thing, just cut to the chase a little bit. Mr. McDonald and I discussed this. The court keeps talking about foundation.
Would you use the microphone because that fan is blowing?
Oh, I didn't see the microphone. Judge, can you hear me now?
Yes, I can hear you now.
Okay. So, Judge, just very briefly, when you talk about things that the court for foundation, it'd be no difference in the course of the trial if you're the state of Ohio and present all your evidence, and you forget to establish something as simple as venue. You do not tell the prosecutor at some point in time, you know what, before they arrest, you forgot to
I
prove
had it
venue.
happen. The prosecutor was Eddie Sullivan, and it really hurt to do it, but there you go.
So, I mean, in terms of, to buttress what Mr. Schlack had said, if the issue is value, and you don't prove value to get to the felony level, you don't go to the prosecutor and say, hey, by the way, you proved that this item was stolen, but you didn't prove the amount.
But see, I'm not going to elements. I'm talking about, I want to know the state's position. Have you presented?
I know, Judge, but it's the
Because
same.
I'm changing the question, aren't I? The question was, are you going to present other witnesses?
The bottom line is, it's the same, whatever your question is to the state, it's the same issue that I just presented. You're coaching the state's case. You're saying to the state, do you have this witness to prove to get to the next level? In order to get the conspiracy, are you putting this witness on? Translated further, if you're proving that this item that's stolen was more to meet the felony requirements and you didn't put it on, are you ready to put on before you arrest a witness to set value?
I respectfully disagree. I think it's entirely different. Here we have an evidence rule which is difficult to apply. It's 801. You can only present certain kinds of evidence only upon independent evidence of the conspiracy. I'm up here trying to figure out whether some witness's statement about what Ms. Smith said is excludable hearsay or admissible evidence. So I need to know, in a case with a complicated fact pattern, is it your position that you have laid the proper foundation?
Which is the same thing. You're asking them, can they prove their case?
No, I'm saying, help me understand if you think you've presented this independent proof of a conspiracy. I don't want to make a ruling or exclude it without hearing your argument. Which is why I'm not asking this in front of the jury, I'm asking it in front of counsel.
That's what Rule 29 is for. Did you prove what you said you were going to prove? You don't tell the prosecutor or advise the defense if you've been able to prove what you're supposed to prove. Because that's
Mr. Milo, you seem to be skipping over this part where the court is up here trying to make a ruling on whether a witness's statement is excludable hearsay or admissible evidence, and that depends upon whether there's been independent evidence of a conspiracy, and I don't know how to rule unless the lawyers talk to me.
Well,
And again, why do I want them to talk to me? I just want them to argue. If they say they've introduced the evidence, well then tell me what it was, because I'm not sure I've got all the pieces of the puzzle put together.
Well, I'll just say this in closing, Judge. You used the word lawyers. What you're doing in this case, you're talking to a lawyer. You're not talking to lawyers as an evidentiary issue. What you're talking about is the basis of burden of proof to prove your case. It's totally different.
I'm not talking about the burden of proof to prove a case. I'm talking about the admissibility of a witness's statement, which under 801 depends upon independent proof of a conspiracy, and we know that under Carter and Jalowitz, you can sometimes introduce the hearsay statement first, follow that up with independent proof of the conspiracy, and turn that hearsay into admissible evidence as a result.
In this one, you're asking the person, you're telling somebody what witness to put on. That's a little bit, out of respect to the court, that's a little bit different. You're asking, are you putting a witness on in order to prove the conspiracy against Ms. Smith? That's different.
Well, actually, the question was, if any of the witnesses prior to Williams will tie in Smith to the conspiracy.
Then why don't you wait for the testimony to come out? You haven't even heard testimony for that day. Why is it like a scouting report ahead of the trial?